Hey, everybody.
All right, I just changed you to the host, so you should be able to share your screen.
Let's see.
Jeremy, give it. Yeah, can you hear us? Okay, thank you.
All right, awesome.
Hi, Jeremy. And did you email this out to us too?
No. Okay, I'll email that to you. Yeah, so you can share it with everybody.
Yeah.
Yeah, I was updating it as recently as this morning.
He's gonna email this out to us too. Oh, good. I'm gonna get some paper and take that.
I'm trying to figure out what's going on here with this, occupancy.
Yeah. I'm sorry.
Okay, so I have two, Courtney, that are going to be sent to you.
Okay.
Because one of them is just on the leases, and then I know you asked me to go over the post occupancy too, but I have like an addendum training that has that in there, so I'm just going to send them both to you.
Okay.
Because I'll cover as much as I can.
Okay. Hey, Wilton Manor's office.
Okay, everybody, this is being recorded, so if you have like something that you want to, a question or something you want to say, if you could talk loudly so the people that, or so we can like keep it.
Yeah, and for everybody that's not in the office with me here, I'll try to repeat any questions so that you guys can hear it as well. So, Josh, I know you said the sound is a little bit weird. Can you hear me better now?
Yeah, it's on our side. I just figured it out. So we're all good.
Oh.
Thank you.
Okay, cool. All right. And then Courtney, I'm going to leave the chat over here just in case anybody asks anything.
Okay.
Because it's easier for me to see that.
Yeah.
Okay, so Courtney asked me to come in and review leases today and post occupancy agreements. So I put this together for you guys, and I'm going to try to cover as much as I possibly can regarding leases. And I'm going to start with the listing agreement for leases. Okay, so the listing agreement for leases is different than the listing agreement for purchase and sale. You can have a purchase and sale listing agreement that includes leases on it. So if you have a seller that wants to sell, but then they're okay taking a renter, you can use the regular listing agreement for that. Try to sell the property, but if you get a tenant, you can still operate under the terms of that listing agreement. You don't have to have a separate lease listing agreement if you are also selling the property. Okay, so this lease listing agreement is for properties that are just going to be rented, not properties that are going to be sold as well. Okay. In the first part here for authority to lease, this covers you guys for the entire duration of the listing period. So if you have a listing agreement that is a year long, and it starts, let's say now in April, and you lease it at the end of May, your listing agreement is still in effect for the whole next year until April. So if that tenant leaves and does an early termination or something like that, The landlord has to come back to you to list the property again, because you have a valid and enforceable listing agreement. Okay, so that's what it means here when it says if the property becomes vacant during the listing period, owner and broker remain obligated to perform. So you will remain obligated to list the property and try to get a new tenant, and the landlord is obligated to relist with you when they have a vacancy. Okay, so there are a lot of tenants right now who are canceling leases early. They have early termination fees, might be 2 months or something like that, and they're looking to buy. So there's a lot of people who are leasing, and then they're still continuing to look to purchase because there's no inventory. And then what they're doing is they're negotiating an early termination for 2 months, 2-month penalty basically, and then just canceling the lease and paying the 2 months and buying their home. So you guys might be able to get a tenant that's like that wants to continue looking to purchase, but they need somewhere to live right now. Maybe they got to get their kids into school or something like that. We've had a lot of those. So this covers you. So make your listing agreement as long as you possibly can, because you never know what a tenant is going to do.
And then you need to find someone else.
Yes, if you have a valid listing agreement, then you will need to find somebody else for the landlord if the tenant cancels. Yeah. So during.
What about their agent? The one that listed the rental?
Well, this is your listing. This is the
I was
listing lease,
thinking-
the lease
okay.
listing
All right.
agreement.
No, I was thinking the opposite.
Yeah, no,
But you
no,
gotta-
from the
you gotta
from the
rent it.
tenant side, you don't have to do anything further.
This is only if you're listing a rental.
Right,
Okay.
this is the
Now I
lease
get it.
listing agreement. Yeah.
Okay.
Okay. Description of the property, including appliances. Most, well, I shouldn't say most, I guess a lot of properties are rented with the appliances in there. You need to be very, very specific as to what appliances are included in the lease, and what your landlord is including, because you might be looking at a property and you're going to be listing it because the buyers are going to move out. There could be a refrigerator, there could be a washer and dryer. You need to find out from the landlord whether or not that is theirs or the tenants, because the tenants could put their own appliances in there and they could be taking it with them when they move out. And you can't just assume that all of the appliances that are in the property are going to be transferred or remain there for the tenant. So you have to be very, very clear on that with the landlord. Of course, if the place is vacant and there's all appliances there, obviously confirm that those appliances are going to remain there. But most likely they are. You have to be very careful though when there's a tenant that's in there already. And then if there is a tenant that's in there, you got to check off the box that it's currently occupied and that the lease term expires on whatever date it expires, because you're going to need to be able to tell prospective tenants, yeah, there's somebody in there right now. They're going to be out by this date. So the property is going to be available to actually enter into whatever date it is. Most leases state that the landlord can go into the property and show it to prospective purchasers or tenants while the current tenant is there. But every lease is different, so you need to confirm that. There are some tenants that specifically negotiate for the landlord to not be able to enter the property to show it to new tenants until they're out. It's very rare, but it does happen. So you need to be, you need to know what the current lease actually says, because you can't just sign a listing agreement hoping that you're going to go in there and show the property and then list it on the MLS, and then all of a sudden you can't show it. Okay. Yeah, question.
Because I think I read on the actual part of our lease, and the definition, it says that the landlord does have the right to enter at any time, as long as they give like a 24 or 48 hour notice.
Yeah, it doesn't say 24 or 48 hours. It says reasonable notice. That's on the standard lease. We're going to go through that. The rental period and rate. Generally, you're putting in a monthly rental rate. You could have a yearly, you could have a weekly, you could have a seasonal rental. If you're going to be doing something with Airbnb or something like that, I know some of you are getting into property management. You can put all of that information here. I always think that putting more in there is better. So you could list the property and the landlord could be expecting to rent it out for on a monthly basis and sign somebody to a year lease. But who knows, maybe somebody else comes in and says, listen, I'll pay you double market value if I get to stay here for the next 3 months. Okay, you know, if you have a dollar amount here that is seasonal, you know, for 3 months or weekly, whatever the rate is, your landlord, when you present them with something, can't turn that down because they've agreed to it here. So if you have a weekly rental rate, you know, of $250 a week, and you get an offer at $300 a week for 4 weeks or 5 weeks, whatever it is, the landlord's obligated to take that. Otherwise, they have to pay you a commission if you present it to them, and, you know, and they don't have a different offer that they're taking. So it's always better to fill in everything on here because you never know what you can negotiate. If you have a monthly rate at $1,000 a month, okay, but you have a tenant who's coming in and saying, listen, I'll pay the landlord $10,000 up front for the year. Well, you know, maybe you should talk about that with the landlord first before you even list it. Maybe there's a discount if they're going to pay the whole year up front, because the landlord would rather have the whole year now than have to wait to get paid every month. You never know what could happen. Yeah, question.
When it comes to like the period of time, is it possible for them to check off all 3? Is like with the.
Yeah, so the question is, can you check off all 3? Yes, you can check off everything here. And my recommendation is to, you know, if you're force the landlord to say, no, I will not consider taking a yearly rent. That doesn't make any sense though. If they could be paid a whole year up front, why wouldn't they do that? And then if they could be paid well above market value for seasonal rent, well, who cares if they have to pay taxes on it? They're making more money, right? Okay. Advance rents, deposits, and fees. You're going to check the owner box here because you guys do not want to accept money on behalf of the landlord. When you guys give us a check for rentals, we are holding that money on behalf of the landlord, not on behalf of the brokerage. So you do not want to say that the broker is holding the money. And then it's going to be in a non-interest bearing account because our account is an escrow account. Now, the way that rentals work with us and how I recommend doing it, if you have a monthly rental, let's say it's $1,000 a month, listing side's going to get $500 commission and the renter side is going to get a $500 commission. You have the tenant put $1,000 in with us, and then when the lease is signed, you have us release the 500 to the listing side, 500 to the renter side, cooperating broker, right? And then have the tenant pay the landlord directly their security deposit and their last month's rent. That way, we don't have to hold extra money from the tenant. Your tenant doesn't have to put more money down before they actually sign a lease. And then you guys are securing that you have the commission to be able to be paid to you, and it's just coming from us. You don't have to worry about the landlord paying you. You don't have to worry about the tenant paying you. You're putting the amount of commission in escrow with us. You're making that dollar amount the escrow. Okay. And then when the lease is actually signed, then the tenant could go pay the landlord separately. And you guys can wipe your hands clean and you don't have to deal with it anymore.
So it's always seen as the first month's rent, not the security that you guys hold, right?
Yeah, it's what, so the question is my office holding the security deposit? We're holding whatever you guys tell us to hold, basically, right? We do this as a courtesy for you guys, but I'm saying the easiest thing you can do is take 1 month's rent, which is usually what the commissions are, okay? And then that way you're not submitting us 5 different disbursements form. Oh, $500 has to go to the landlord, $500 has to go to the listing agent, the security deposit has to go to the landlord. Plus, when you do that, you're making the tenant put a ton of money in escrow with us too.
Because it would have to put, if it was $1,000 and it was seen as the security deposit has to go back to the landlord.
Right, all of that money is going to have to be transferred to the landlord anyway. So don't make the tenant put it down with us to begin with. Just have them put 1 month's rent with us. And that is basically when you're submitting the offer, we'll get down to it. You're saying that month, that much is in escrow, and then everything else is going to be paid to the landlord, either upon move-in or upon the lease being signed. Okay, that's how to make your guys' life easier. Makes my life easier too, but ultimately we're just cutting checks, right? We're being told these are the checks that we need to cut. But now if you guys have to worry about 5 different checks being cut, now you have to make sure that your disbursement form is correct. Now you have to make sure that the money is transferred to the right person. The landlord gives you the right information. All of this extra stuff that you really don't need to do. You want to get the landlord and tenant to sign the lease, and then you want to get paid. Okay. You can have advanced rent. Advanced rent would be like first month and last month. And then the security deposit is generally also 1 month's rent. If you're doing a yearly lease, that's going to be negotiable. Okay, but it's generally about 1 month's worth of rent. Pet deposit, a pet deposit could be refundable or non-refundable. Okay, if a tenant has a service animals are not considered pets under Florida law. So the landlord is not supposed to be collecting a pet deposit for service animals.
Does it matter whether it's DSA or service? Is it different?
No, it doesn't matter anymore because the statute is emotional support animals. And service animals are, they're covered under the same statute now.
Really?
Okay, yeah. Yeah, there's last year, emotional support animals, you can't discriminate against a tenant that has an emotional support animal. Okay, if we have time at the end, I'll pull up the statute about that. Credit report fees they can collect, application fees the landlord can collect. If the lease is 6 months or less, there's going to be a transient tax from the state. So most leases are going to be 6 months and a day, or they're going to be a year. So if you have a lease that is less than a year, you need to make sure that your landlord knows that if it is 6 months or less, they have to pay an extra tax on it. Now, the landlord can just charge the tenant that tax. That's okay. But they have to know that it has to be paid by the landlord. All right. And then if your landlord says, well, can I collect the tax and then not pay it? Your answer to that is, well, I'm not an accountant or an attorney, so ask your accountant or your attorney. Don't give them legal advice or tax advice. The answer is yes, they have to pay the tax, but it's up to them if they pay it or not. And then if the state finds out about it, then they'll come back and they'll penalize them, and it's a lot in penalties for not paying taxes. Broker obligations. You guys have to use diligent effort to lease the property. Whether it's a lease or a sale, when I get contacted by clients who are upset with their agent, it is usually because the agent is not showing the property or showing up to showings. They're not answering phone calls, and the landlord or the seller finds out about it. So, you guys need to make sure that you're doing that, and the listing agreement says that you need to use diligent effort. Sometimes you guys come to me and say, hey, I have a client who's upset with their realtor. How do I get them out of the listing agreement? This is the section that they use to get out of it. They can document, hey, this person's not answering the phone call. Hey, this person's not showing the property. And then we can go to the agent. You can either have, you could go directly to the agent if you want, but usually it's like a broker to broker conversation. Hey, the client wants to get out of this listing agreement. Why don't you let them out? Because there's all this evidence that you're not doing what you're supposed to be doing. We'll go into later what the early termination states, but the landlord doesn't have the opportunity to just cancel this. Okay, it's up to the broker as to whether or not the landlord can cancel this agreement. Okay. Lockboxes. Be very careful with lockboxes. If you have a lockbox on a property, you need to explain to the client what a lockbox is, and that any realtor who looks at the MLS and sees that there's a lockbox or a Supra on the property can go there and they can open up the property. I had a realtor show a property one time, and then it was like a Saturday. And then on Monday, the listing agent called him up and said, hey, did your clients move a couch into the garage? Turns out that the client that was looking into the property went under contract on Saturday and then came back with one of their realtor friends on a Sunday. Wasn't their agent that was involved in the transaction, but I think it was their cousin, came back with the Supra, went back into the vacant property and moved stuff into the garage, including a couch. So your client needs to understand what a lockbox is, what a Supra is, and then also later in this agreement, it protects you. It states that you guys are not liable for what other people do with a lockbox. Okay, so this protects you, but you're going to have an issue with a landlord or owner of a property if you have a lockbox on there and somebody abuses it. So you do need to explain to them what that is if they want to use one. Okay. Credit check. I highlighted this, and this is a little bit hard to see. I don't know why I got screwed up, but do not state in your listing that the buyer must pass a background check or a credit check. Does anybody know why I say not to put that in there? Kyle.
Fair housing.
Fair Housing Act.
I've seen that all the time now.
That is a Fair Housing Act violation. It is discriminatory.
Report.
Yes,
I see
it
all
is
the time.
discriminatory to put in a listing that a tenant must pass a background check.
Can they say it's required though, and then the landlord will review it?
I would not put any of the application requirements on there at all. You could put the application itself on the listing. If the tenant calls you up and says, the application says I need to pass a background check, I have a marijuana charge in my background, will the landlord accept me? All you should say to them is, I have no idea. You need to fill out the application if you want to apply, and the landlord will determine whether or not you qualify. You cannot put must pass background check. All you can do is say the landlord has an application. Here it is. Fill it out if you want to apply.
Can it say like 600 or more credit score?
I would
I've
not
seen
put
that.
that on your listing.
I've
What if
seen
it's
that
an
also.
HOA requirement? I've seen that a lot where the.
I
HOA
also would
requirement-
I would not put any of this stuff in your listing, because I have seen agents get sued from these attorneys who represent indigent clients, and they say that it is discriminatory. Okay, you as an agent, first of all, that does not help you in getting, it doesn't help you at all, right? Put the application up there. You are making no comment as to what the application process is for a landlord or an association. Here is the document that is required to be filled out, tenants. They call you up, they start asking you questions. You know what? You're going to have to ask the association about that. Why don't you apply and ask them about it then? Okay, you are under no obligation to give any advice to anybody about any of this stuff. You should not be making any comments about it, because there are shoppers that go around and they try to find agents that they can report for Fair Housing Act violations. And it doesn't matter whether or not you actually violated it or not. They will file a lawsuit against you, and then you're going to have to end up settling with them. And then you're going to have, the settlement agreement will be for you to do community service or put something on your website or all sorts of different things. I've had to negotiate these settlement agreements before with people over the stupidest things that, in my opinion, are not Fair Housing Act violations. However, it doesn't matter because it's going to cost you more money to fight them in court. So do not make any comments about background checks or credit reports on your listing. Okay, just put the application and say, you're going to have to ask the association about that and fill out the application. If you have the landlord and there's no association, you could say, you know what, you're just going to have to fill out the application and the landlord will review it. I can't make any comment as to whether or not someone is qualified.
So if they fill out the whole back or the screening,
Yep,
the landlord can say, no, I don't want this person.
exactly.
But you're just.
They
not
could say
putting-
they did not pass the background
You're
check.
just not
But
putting
you
it out
cannot advertise, similarly, you can't make comments about religious things, anything like that. Like I had somebody, one of the classic examples, it's like a favorable thing, synagogues in walking distance. Okay, that is a Fair Housing Act violation, because if you do that, you could be discriminating against Jewish people by saying, like, by preventing other people who are racist against Jewish people who now don't want to live in that, so you're steering people away if they're not Jewish, that type of thing. You do not want to make any comments like that in MLS listings, okay? If your landlord tells you that they don't want to accept, insert racist remark, insert poor people, insert anything. If they tell you that, just disregard it and say, you know what, I can't do anything that's going to put my license in jeopardy. If you have an application, give me the application and the tenants can fill it out and you can determine who you accept and who you don't accept. Okay? And if they don't accept somebody and they're discriminating against them, that's not on you because you did not make that decision. If they don't accept anybody for some reason, and you don't know the reason why, great. Don't find out what the reason why is. Just say that, I don't know, the landlord didn't accept you, go talk to him. You don't want to be involved in something like that.
Wow, I really, 'cause I see it all the time.
There's a documentary, I believe it's on Netflix. I forget the name of it, but I'll see if I can find the name of it. And it's all about steering and shopping and things like that. And there are these shoppers that go around and they apply to a million different places and they just try to catch realtors in Fair Housing Act violations. And they do this. And then they have law firms that are associated with them that will file lawsuits against them if they find somebody. So you have to be careful about what you say, and less is more. Don't make any qualifications to anybody about whether or not they will or won't get approved. Okay. And then similarly, if someone's asking you to find a property in a location, whether it's a rental or a purchase, you can't look at that person and say and think like, oh, this person must be rich. This area of town will be great for them. But something else that met their qualifications, $4,000 a month for rent, 3 bedrooms, wherever the heck it is. If you didn't do the search and show them the property that's out west, you could be discriminating or steering. So you need to plug in the numbers that they're showing you, and you need to show them all of them. Not physically go to those properties. You need to send the MLS listings that meet their criteria. You can't do the search for them and say, if they tell you I want to look in Boca, okay, do the search in Boca. But if they just tell you $4,000 a month, 3 bedroom, and your search yields things in Boca and Del Rey, you can't just show them the Boca ones because they didn't ask you just to look in Boca. They gave you a criteria that was $4,000 a month and 3 bedrooms.
Or leave out Riviera Beach.
Right.
Just, don't say that out loud, this is being recorded.
We got you on.
You have to be careful about that stuff.
I don't do anymore.
Well,
What
what
about
about
if they
clients
ask
that
you-
ask you about like crime rates in neighborhoods? I've always been taught, you just say, I can send you a link
Well,
or
the
you
crime
can look
rate,
up.
no, but schools?
School
If
districts,
somebody says,
I
I'm
wanna be in
looking-
a good school
should you just
district.
refer them to?
What
the
you
Palm
should
Beach
do-
School board
That's what I
website?
do. I send them a link.
do the search for the monetary criteria and the criteria that is neutral, and give them all of the different properties. And then if they start asking about school districts or crime rates or things like that, okay, those are the things where you can give them the links. Here, go look up what the information that you're looking for, you have to go look it up. These are the properties that meet your criteria for, financial criteria, right? And then the reports that you give them, you cannot cull them down for different things that can be discriminatory, okay?
But like I've had a client who said they told me exactly the elementary school they wanted to do.
If they tell you, I want to look for properties that are in this elementary school, that's different because now you have to search for all of the areas that are for that elementary school. That's totally different. They are requesting that you do that versus giving you something that's open-ended and you have in your mind, oh, this would be a good area for these people. Why? You know, you don't know that. So you have to be careful about that stuff. And always get in writing what your client is requesting. Okay.
Like the email or.
Yeah, have them email you or text you. Yeah, I want to look at properties with this. Okay. And then give them the properties with that specific information. If you start adding stuff in there, that's not what they asked for.
So like with sync, when we take information in regards to like, when we're asking general questions, we usually list everything that they told us in that conversation. That was over the phone, and that's me answering that as like a paper trail. So
Yeah.
I didn't have to go back and just like, hey,
I mean, you could take notes if you're on the phone, but yeah, take notes and then you can confirm with them, email them, hey, you know, just to confirm, this is the criteria that you asked for. Okay. And here's the criteria. If you need me to change the criteria, let me know. Okay. But you're plugging stuff into a computer and having it spit out information. Okay. If any of the stuff that you're plugging in was discriminatory, you don't know whether that person is a shopper that's asking you. So they could be asking you to plug in stuff that's discriminatory too. Now saying I just want houses that are for this school district is not discriminatory, right? But there are certain things that can be discriminatory and you need to know whether or not someone's asking you for that. And then you can't give them that information. You have to give them more generic information. So if they ask about crime reports and things like that, you could say, listen, I'll plug in your criteria you want to give me, and then you guys can look up, you know, other different things on information that I can't give you. Okay.
I would just say like, it's always, Lynn should just always revert back to as a Florida realtor,
Right.
I cannot do it. So that way. people
Yeah, Kyle.
understand.
Yeah, Kyle's saying as a realtor with a license, that's something that I'm prevented from doing.
So that's your automatic, you know, safe
Right.
haven for them thinking they're difficult and I totally don't want to help. As a realtor.
Yeah, and then you could give them, you know, you can give them your report, and then if they want to narrow down their search based on other criteria that they're giving you, okay, but it can't be discriminatory criteria. Okay, owner obligations, you guys are protected by this agreement too. So if the landlord gets a prospect, they have to refer it over to you guys when you have a listing agreement. They can't just get somebody themselves and you not get paid for it because you're advertising the property. So we have to assume that your advertisements are leading to tenants. So if that tenant walks up to the property and starts talking to the landlord, okay, because they're trying to cut you out because they think they'll get a better deal, you are still supposed to get a commission on that. Okay. It's important for you guys to talk with the landlord about this too, so that they understand, so that there's no surprises and that you don't get somebody later that's like, well, you didn't do anything to get this tenant for me. And then they start arguing with you, you know, be on the same page with them to begin with, have that conversation. Why are they hiring you to begin with? You know, if the owner or the tenant terminates a lease, they need to notify you. We talked about this earlier. If the property becomes vacant during the terms of the listing agreement, during that time period, you guys are supposed to relist the property and get another tenant. The broker has to relist and the owner has to tell you when it's terminated. Here's the part that protects you about the lockbox. You are released from all liability. Here's the discrimination language. The landlord may not restrict the rental property according to race, color, religion, sex, handicap, familial status, national origin, or any other classes protected by state or local law, and not to ask or expect broker to impose such restrictions on the rental of a property. So again, if a landlord asks you to do something like that, you can point to this section and say, no, we are not allowed to do that. And if they keep pushing you, then you shouldn't have that person as a client. You don't want to get involved in something like that because you will get sued at some point. It happens all the time.
So let's say this case happens where, you know, you've done your job, the other agent comes in with their renter. And, you know, they have a great credit score, they can show the money and everything like that. But maybe they're just not the class or whatever people, or whatever the landlord decides to say, no, I don't want to take it, regardless of anything you've done. Are you still, I mean, can that agent come back and say like, you know,
If the agent, so the question is, what if the landlord blocks somebody from coming in and you don't know the reason why? Maybe you suspect it's discriminatory, or maybe the buyer's agent does, but you know, you don't know anything about it. So your response to the agent is, I don't know why the landlord rejected them. It must be for some reason, but I don't know what that reason is. And that's it, you know? If the buyer or the tenant thinks that they were discriminated against, they can go talk to an attorney and they can go figure that out. But you don't have to give any more information, and you should not ask the landlord why they rejected somebody. That's not for you to get involved in. And then if the tenant comes back and tries to sue the landlord with no information, the more, like, if I'm an attorney and I'm digging around, I'm talking to the listing agent. I'm saying, oh, what happened? Blah, 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 blah. A lot of times listing agents know. You know, so you need to protect yourselves. And if you know that it's a reason that's discriminatory, you need to put the landlord in touch with an attorney. And then you need to tell them you cannot decline somebody for that reason. And I'm not putting my license in jeopardy over that, you know?
yeah, I was just trying to see how it would be.
So that's why before you have the listing, you need to go over that stuff with them too and say, you are not allowed to do this, and do not ask me to do that. Because here's the other thing too. You guys as agents are bringing a ready, willing, and able tenant, and then the landlord is discriminating against them and preventing the lease from happening. You're owed a commission. So if you know that the landlord is discriminating, you guys can sue them for discrimination to get your commission too.
I think you have questions.
No, it's older. Okay. If you deny a service member, then the owner has to give them the reason why.
Good.
Yep, protect, that's a Florida statute, not federal.
That's military, and what about like firefighter?
In the Florida statute, it defines what service member is. So you could look that up later if you need to. Okay, I'm gonna skip over a couple of these. Okay, compensation. You guys are entitled to your commission regardless of whether or not the tenant fulfills the terms of the lease. Okay, so if the tenant breaches the lease, the landlord doesn't get to come back to you and say, oh no, you know, give me part of your commission back, right? It's upon the signing of the lease, you are entitled to the commission, okay? Once you procure a tenant who is ready, willing, and able to lease. The amount of compensation you're going to put here, it's either a percentage of the rent due each period, or a percentage of the gross value, or a percentage of the first month's rent. Okay. It's difficult to put all of them on here unless you're clarifying. So if it's a short-term rental, then you might be getting a percentage of the rent for each period, because you don't know how long the rental is going to go on for. And if it's week to week or a seasonal rental or something like that, you may want to have that. So if you are checking off more than one box, you need to clarify it probably. Okay. Gross value of the lease. If the tenant is signing a 5-year lease, you know, if you have a commercial property or something like that, there's a different listing agreement for commercial property. Okay. But, you guys are not allowed to do a lease and put it together that is more than 1 year, but the landlord could do that themselves. And the landlord could have an attorney that's putting together a 2 or a 3-year lease. And so you might be entitled to a percentage of the gross value if that's going to happen. Generally, if landlords are doing that, they have somebody that they're working with, whether it's an attorney or they have their own form lease. And so you guys need to know that too. But you cannot put together a lease that is for more than a year. Okay. And if it's a percentage of the first month's rent, it might be 100% of the first month's rent. If you are going to split with a cooperating broker, do not put 50% of the first month's rent. You are still getting 100% of the first month's rent. And then the cooperating broker is getting half of your commission. For the time and manner of payment, I highlighted this one because I think it's the best one. Owner will pay broker's fee within blank calendar days after entering into a lease. So like we talked about in the beginning, if you have $1,000 in escrow with us and 500 supposed to go to you and 500 supposed to go to the other side, you want that released to you as soon as the lease is signed. So within 1 day of the lease being signed, you should be able to get the commission sent to you. Right? That's the clearest, easiest, best way of doing it. If you're waiting until after the tenant occupies the property or something like that, you're opening up a can of worms and you're preventing yourselves from getting commission that you earned quickly. You're entitled to commission on new leases and renewals with the same tenant. Okay? So year to year, if that tenant keeps renewing, you're supposed to get a commission every year.
How do you enforce that?
You got to keep checking. You got to follow up with people, follow up with the tenant, keep your CRMs, keep all the people in there. Hey, you rented this property last year. Are you renewing? Find out.
I've seen in listings where it says no renewal.
Yeah, no renewal commission.
So what-
Yeah, if there's no renewal commission, this part needs to be
cross that.
modified.
Does that just apply to just the listing agents or to the tenants agent?
So the cooperating broker commission is listed here. And
So will the listing agent every year get that full month? And the price, and probably doesn't get the other-
yeah, there is no protection here for the cooperating broker for renewals.
And follow up when you're ready to purchase something.
And that's the thing too. Why do we do rentals? Some rentals are lucrative, right? But especially if you're an agent who's just starting off, you're probably starting off with rentals. In 6 months, you should be following up with that tenant to say, hey, you've been paying for 6 months. Are you building any equity so that you could buy a home? Because it doesn't make sense to keep renting forever. You need to build equity, right? If they need to repair their credit in order to get a loan, they need to start working on that 6 months before they're ready to start applying for a loan. If they need to have money in their pocket for a down payment for a home, they need to start putting money away to be able to get that down payment. It doesn't make sense for people to continue paying month-to-month rents when they could own a property and potentially be paying less, you know, for the same type of property.
I had a buyer that had rented for 20 years. before she
Wow.
bought something.
20 years. Imagine if they just put away $100 a month for 20 years.
I know.
They would have had, you know, plenty of money to pay for,
Cash.
you know? So this is what you guys need to do as aggressive, active agents to be able to get more commissions. Follow up with your clients, and you're not just doing rentals for that 1 month commission, right? You're doing it for the long term to build a relationship with that person. Maybe they're going to rent again and you're going to help them find something in the future, or maybe they're going to buy. Repeat customers.
Maybe they have a friend.
Exactly.
Or
Maybe they have a friend.
But one comment, you know how many times we get, well, I get, how can we get leads? Can we buy leads, all this? I'm like, have you reached out to your previous clients, like your renter, you know? I mean, they
Right.
know you already, you're already proving yourself to them.
Andre's talking about how do we generate new business, right? We can buy leads. Okay, leads are a number game. You guys have to do cold calls. You got to follow up on them, right? But if you are not farming your own list of people that you've done business with before, you're doing yourself a disservice, because those are warm leads. They're not cold calls. Most realtors that do an excellent job have a client base that is constantly referring them more business because they had a good experience. And that's relationship building. You know, it's not just a one and done. Okay, I got these people in there and then I'm done with them. Follow through on different things, you know, do follow-ups with them. Have, you know, there's a lot of different scenarios with follow-ups now. There are inspection companies that will remind people who have bought a house that their appliance warranty is coming up or something like that. You know, there's all sorts of little things like that that are automated now that will keep your face in front of the client. But the best person for doing that is you guys. So a lot of agents will have their follow-ups. You know, part of their week is dedicated to following up with past clients, because the best source of future clients is past clients. So anyway, that's an aside, but this is why we do rentals. It really is. Do rentals so that you can get buyers in the future. Turn those renters into buyers. Some renters right away are eligible to buy and they don't even realize it. So instead of looking for a place to rent, you might be looking for a place to buy. Dispute resolution, just like the as-is contract, you got to start with mediation. Do not have everybody initial the arbitration. Nobody wants to go to arbitration. You guys don't want to do it. If you have to sue a client, you'd much rather just go to mediation and then sue them afterwards instead of having to go to arbitration.
So if you signed arbitration before mediation?
Yep. No, you do mediation. You always do mediation first. And then if you had everybody initial the arbitration, then you have to go to arbitration instead of going to court. And usually it's more annoying to do arbitration. Brokerage relationship, most of the time transaction broker. You can be a single agent for the owner, and you could be a single agent for the owner with consent to transition into a transaction broker, because if you procure the tenant, then you can transition to be a transaction broker. That's a company decision. It's an individual decision and a brokerage decision as to whether or not you're going to be a single agent, because you have different responsibilities towards the landlord. If you're a single agent, you have more responsibilities. So there are very few agents that act as single agents. There are some that do it, but that is a company policy and a brokerage policy, and there's a method to their madness, and they have a whole marketing campaign built around doing that. So if you're not going to do that, then don't do it. Just be a transaction broker. Additional clauses, sometimes we have changes for renewals listed here. So it says, you know, what the commission might change if you have a renewal or something like that. You can put that all in the additional terms. Okay. That's the listing agreement. Anybody have questions about the listing agreement? Okay. Again, the listing agreement for leases is different than the listing agreement for sales. If you have a property that you're going to sell, but the owner might lease it, you use the other listing agreement. Use the one for sale. You do not need to use both, because there is a spot in there for if you lease it as to what your commission is going to be. Question.
On the first page, when it talks about making final inspection and inventory check of the property.
First page, yep.
At the bottom.
Yes.
Boxes. What do you suggest? I mean, usually the landlord will say, you know, here goes, walk through the property, how does it look? Would you recommend to check that off, or for liability purposes, if you miss something, the landlord?
Yeah, I would recommend not checking this box off, because then you are obligated to do an inventory check at the end of the lease. These are broker obligations. So you don't want to have to come back a year from now. Most landlords forget about this and they're not holding you to that, but it is something that they're supposed to be holding you to, and it is a broker obligation. So I would not check that box off. Okay. Similarly, the withhold offers, I always want to have that checked off. You don't want to have to come to your landlord with a new offer that's better than the one that they just got and they signed a lease on, Because then they're gonna try to get out of the lease and go with that offer. Right? So you want to have the box checked off for withholding offers. Okay. Before we get into the actual lease, I wanted to show you guys lease termination letters. So if you have a landlord that needs to get a tenant out, they will most likely come to you and they will ask, what letter am I supposed to give to my tenant to get them out? This is a lease termination letter. Okay. They will be required to vacate the property by whatever date. If they are on a month-to-month lease, they have to have at least 15 days notice. However, if you're in Miami, you have to give them 30 days notice. I normally recommend giving every tenant 30 days notice to vacate a property. If they are on a 1-year lease, I usually recommend giving them 60 days notice that you are not renewing the lease. You can give them a lease termination letter, or if they are on a 1-year lease, you can give them a non-renewal notice. Okay. There's a little bit of a difference between a lease termination and a non-renewal. The lease termination is when they're on a month-to-month lease and they've already gone past their year lease. If they are still within their year lease and the landlord's not going to renew with them, then you give them notice for that. The lease itself, the FAR lease, says that in order to renew for another year, you have to sign a new lease. So if they don't sign a new lease, then they're just month to month after that. Even if they all agree that they're paying for another year and they're going to stay there for another year. If it's not in writing, they do not have a yearly lease. Okay, so those documents are in there. Contracts to lease. Some of you have heard this before from me. I do not like contracts to lease. They are binding letters of intent. It's not a lease. You do not get any commission from it, but the section 2 has the tenant place a deposit. Okay. And then it says here, the tenant has paid X amount of dollars to blank. One time I had an agent who put that the tenant has paid $2,500 and they put their brokerage there. The tenant never paid $2,500 to the brokerage. Then they did not execute a lease and they were gone. The broker had to pay $2,500 to the landlord because they had their client sign something stating that they had already collected this money. So you need to understand what a contract to lease says. It says that they have already paid this deposit to whoever's holding it. If you put our company there and we have not received the money yet, this is a lie. Why is this important? Can't the tenant just back out? No. On the second page, it says failure to perform. If the tenant fails to perform any of the promises in this contract, the deposit paid by the tenant may be retained by or for the account of landlord as liquidated damages. What's one of the promises of the contract to lease? That the tenant is going to sign a lease agreement under the terms that are on here. So if the tenant puts money down, signs this contract to lease, and then says, I don't really like the property, I don't want to move forward, the landlord is supposed to collect their deposit that's written on here.
So don't write a deposit.
So if the landlord, the question is, so do we just not write a deposit?
Boxes off,
What's that?
the chat box. Oh, yeah. Keep
Okay.
in mind. And that one, yes, thank you.
So if the landlord is requiring a contract to lease, on the deposit section up here, I modify this to say tenant will pay upon lease execution, or I put $0 or just put upon lease execution or something like that. You have to change this section somehow or put 0. Okay, and then the money due section is where you're going to put when the money is due. Okay, so if you're going to sign a contract to lease and they're going to pay their first month's rent, their last month's rent, their security deposit, when is it due? Upon lease signing or upon move-in or whenever the heck it's going to be, but it's not right now because there's no lease yet. And then this part says the paragraph 2 deposit will be credited as follows. So if there's no deposit in paragraph 2, then that's not going to be credited here. Okay, question.
So my question is two parts. All right, so when it comes to the person who's holding the escrow, obviously, I mean, you guys would be it, but would we put to be determined in this section right here, or do we still put?
Yeah, you could put TBD, you could put anything there as long as this section is 0 or it's upon lease signing or something like that. The whole point is from the tenant side, you don't want to be putting a deposit in on a contract to lease. You want to have a fully executed lease agreement. And from your guys' perspective as realtors, this contract to lease is not helping you because the listing agreement says that the tenant must be ready, willing, and able to sign a lease for you guys to get paid a commission. This is not a lease. So it's not helpful to you to have this signed. If your tenant is ready to lease a property, fill out a lease and get it signed with the landlord and then collect your commission. Don't screw around with this document. You don't need it.
But if the listing agent's asking.
If the listing agent's requiring it,
That's, I've had that.
fill out a lease and send it to them as well.
But when you do it through,
But don't put a deposit on the contract to
Right.
lease.
but when you do it through Flex, it's a contract to lease. When you do it through transaction desk, isn't it? 'Cause
Well,
I've
there's
done
a
it.
lease, there's a lease in
It's
there.
different.
So
Oh,
these
they're
are two
two
different
different
things.
ones.
They usually use this to, I mean,
Present it on.
I'm just saying, to present, we use
Right.
this to present. an offer.
Tenants, agents, and cooperating brokers use this all the time to say, here's my offer. The problem is, this is not an offer. This is a binding letter of intent. So if the landlord signs it and the tenant doesn't want to move forward, then they're on the hook for the deposit,
Unless you put 0
unless you put 0, because there's no dollar amount there.
Mm.
or upon lease.
Right,
No, because I had somebody pull out of, the contract to lease was accepted. Remember that rental I had? And then my client couldn't move, so he couldn't take it. But I think there was a dollar amount there, but
if the landlord didn't realize that they were entitled to the deposit, then their agent did a disservice to them.
Yeah, because I feel like most agents
Don't
don't
understand.
do that.
Right,
They just use this as a like.
and that's why people get in trouble.
presentation to-
So I've seen enough of these where I have to tell you guys about this because you guys don't see this all the time. So what you're talking about as there was something in the deposit and the tenant didn't move forward and the landlord didn't collect anything, the tenant got lucky. And you didn't have to deal with that situation. The next time that happens, you may have a listing agent and a landlord that says, okay, send us the deposit. And you'll be like, what? Well, now you won't be because you've learned about this. Okay? And it says here on the last page, this contract is not a lease. So what is the point of it? I really don't like this document at all. You know, it's fine for landlords, you know, they're binding the tenant to an obligation, you know, but from the tenant side, it's not a good document.
So can we come up with a document that's?
No, you use a lease.
Right,
Why
but
would you have
you're-
another document?
Isn't it
Because
the
they want-
landlord that does the lease? Not the tenant? That's why you do a contract to lease? 'Cause it's
The
like a-
landlord doesn't have to fill out a lease. The tenant can fill out a lease.
I don't know, the experience that I've had, because I've only done rentals, is that you have to present the contract to lease, and I
Mhm.
guess you put 0 now.
Yeah, I mean,
And
this is
then-
this, so this
Then
is the lease
landlord
agreement.
Would say, okay, I'm gonna offer you a lease now.
Yeah, I mean, you don't have to do it like that, though.
You just fill this out and send it, I guess.
I mean, if you know all the terms, so think about this. Let's go back to the contract to lease. All of the terms that you need in a lease, aside from maintenance, even the maintenance is here, but not all the little check boxes. Almost all of them are in this. So how are you filling this out? You have all the information already. Why aren't you just filling out a lease? And then think about it like this from the tenant perspective. Is the tenant willing to sign the lease? Because this document says they're willing to sign the lease. So why aren't they just filling out a lease and signing it? You guys want to get paid too, right? This document doesn't allow you to get paid.
You know,
Yeah,
like
I would have both of them filled out at the same time if the tenant is requiring, or the landlord is requiring
So
this.
I went to the board and asked them if they had a class on rentals. They do not.
No, they don't have a class
They
on
have
rentals.
nothing, so nobody knows what the hell to do with these.
In any of the classes that I've been through with the Florida Realtors, they read the document. They just read it. They don't, and they say, oh, this section says this, and this section says that. They don't go through real life examples. I had a real life example
Right.
where a broker lost the dollar amount that was there because the tenant never even gave it. It was the agent's very first deal. Very first deal. They never got the money. Yeah, remember? His name was Judd.
Terrible.
I remember the kid, his very first deal and his very last deal.
Was it $4,000?
It was his very, no, I think it was 2,500. Yeah. It was his very first deal and his very last deal. The broker fired him from the agency. Okay, and he did not continue being a realtor after that.
So, can I ask you a question?
Yeah.
Because the one that I told you fell through, I just pulled up the contract to lease because I wanted to see,
Yeah.
because a lot of it was, whatever.
Mhm.
Where is it? Section
Section 2 for deposit.
deposit,
Right there.
1,500.
Yeah, so there was so on the example, we're looking at somebody's screen in the office here, and they had a contract to lease
It's very
that said
serious
$1,500 was
because
collected.
1,500, it was
Yeah,
one
the
month's
landlord
rent.
is entitled to that. Did you guys sign a release and cancellation?
No.
The
Because-
landlord is
because
technically
this-
still entitled to
this
that
is-
then.
This expired, like, but I mean, that's what I was told, like this.
So you have both parties sign that?
both
Did the
parties
landlord
signed
sign it?
Not sure,
If the landlord never
no,
signed
this-
it,
No.
okay, then it's
This-
not valid.
This was just my guy.
So if the landlord never signed it, then it's not a binding contract.
Because he wasn't gonna sign, they were gonna look at this as a.
Yeah.
do you
So now
buy
here's
it?
the other thing. If the landlord signs it, the landlord is binding themselves to enter into a lease agreement too, right?
So now they have to provide a lease.
That's sort of a protection, but it's not, they don't have as much at risk as the tenant does. And then the thing is, in our experience, tenants do this all the time. Yeah, I like this place. Let's do it. I'm in. Here's $1,500. Oh, I need to pay first month, last month, and security, and I got to come up with $4,500. I can't do that. And then they back out. That happens all the time. One of the reasons why we only take cashier's checks and money orders from tenants is because their checks bounce all the time. You guys need to protect yourselves and protect your commission because you don't know these people really. Okay,
So only the landlord would have had to sign this.
the landlord would have had to sign the contract to lease
and
for
they weren't
it to
gonna
be
sign
bound.
it, because then they were ready to give us a lease.
Yeah,
This was just almost like an offer. type
yeah,
thing.
but it's a binding offer. That's the thing.
That's
It's not a
interesting.
letter of intent.
Okay,
It is a binding offer.
that's good to know.
So
Thank
just
That's
write
why
up the
we
lease.
love you.
Yeah. The other thing you could do is you could have a contract to lease filled out and not have the client sign it and send it over. And have the land and say, hey, if you're gonna agree to this, sign it or provide us a lease with these terms.
And you'd fill out all in number 5, all the monies due, that you'd fill out.
Yeah. Yeah, because the money, but here's the thing. So if we're looking at the lease now, this is the residential lease for single family. There's one for multifamily too. And I'll touch on that one briefly because it's slightly different. Okay. You list all the furniture and appliances here. Okay. You put the total rent amount, monthly amount. Okay. And then you're going to be putting in here, when it's due and all of that stuff. It's the same information that's on the contract to lease. Right? I'm sorry that some of these got cut off a little bit. Let's see, you're going to be paying a monthly installment on whatever day. Okay. You have the total rent amount, which is the total rent amount for the entire lease. Right. Then there's the payment summary. If it's paid in full, in installments, then it's going to be the amount of blank. If it's paid in full, then it's the amount of blank. The payments shall go to wherever, and the listing agent can fill in the blanks there too. You don't have to fill out the whole thing. Okay, here is the section It's the same section that's on the contract to lease. First month's rent is due when? On signing or upon occupancy or whenever it's due. You're writing all of that information here. Okay. And I'm really sorry that this is blocked off, but this section here says the tenant is not entitled to move in or keys to the premises until all money due prior to occupancy has been paid. If no date is specified below, then the funds shall be due prior to tenant occupancy. So this is saying if you don't put a date or something here, then the tenant has to pay everything before they move in. Yes, everything that's listed here, the security deposit, the first months, the last months. So you have to be, if your tenant wants to move in and then pay, you know, the landlord's never going to allow all of that to be paid up after move in. Some of it has to be paid before and some of it has to be paid after, right? So your tenant, so realistically, your tenant has to be prepared once they sign a lease to be able to pay first month, last month, and security. Hopefully the first month you guys already put in with my office, and then when the lease is signed, now the tenant's got to go pay the landlord, and then the landlord is supposed to pay you, but we're holding that money with the commission. So that's how we streamline it, right? If the tenant doesn't have the money to be able to pay once the lease is executed, you guys are owed the commission still, because you got a ready, willing, and able tenant to sign a lease. So you have to be careful about how these things are filled out, and you know.
What's the wording in section 2 that you would put? I just want to make a note of it.
In section 2 of the contract to lease.
Yes.
So in the contract to lease, I would put either $0 or due upon lease signing. This section here in the red that says $25 if the face value does not exceed 50, that is section 68.05 of the Florida statutes. That's if a tenant passes a bad check. So I just wanted everybody to be aware of what that was. It can be up to 5% of the total value of the check. So if it's a very expensive lease, passing a bad check could cost them 5% of whatever the dollar amount is.
Says, but not to exceed
3,800.
It's not to exceed the value of the payment.
Oh, the full payment of the check.
Yeah, the face value of the payment. Yeah, sorry about that. I'll modify this and send it back over to you guys so that it's not blocking that. I don't know why it saved like that. Okay, so this section, of course, first month, last month security is standard. There might be a pet deposit or something like that.
Our transaction fee would go. on that.
Your transaction fee could go there if the tenant is paying your transaction fee, right?
Mhm.
Pets and smoking, if there are pets, you got to put the amount of pets and their size. Utilities, tenants paying for the utilities except for. So any utilities that the tenant is not paying for, you have to write here. Then the maintenance. You've got to figure out what is a landlord responsibility and what is a tenant responsibility, right? In this section here, it's different than the multi-unit because the multi-unit lease has a dollar amount where if the maintenance is above a certain dollar amount, then the landlord is responsible for it. In a single family lease, there is no dollar amount. So if you've negotiated with the landlord to say, oh, the tenant is not responsible for paying for maintenance or repairs that are over $500, you've got to write that in the other section here. Okay. So we'll take a look at the multi-unit one in a minute too.
Is that per, is what I'm saying, is that per item, or is that just like in total?
It's usually per item. you know, so you have to specify that. I know a lot of people aren't necessarily doing single family leases, but a lot of people use this as the lease instead of the multi-unit one. And if that's what everybody's operating under, then that's what everybody's operating under. So you got to be careful with that.
I also added there, and I'm not sure if it's correct, but I also added there, insurance. Like tenant will also get an insurance policy for the unit. Like,
Yeah.
contractor is responsible for that.
You can put insurance in this section. I believe there's an insurance section for risk of loss.
Okay.
And the landlord is responsible for risk of loss. So meaning like if the property is destroyed by a hurricane or something like that, that's not the tenant's responsibility. The landlord is not responsible for the tenant's personal property.
Yeah.
And it says that in this lease. If I see the section, I'll point it out. But it definitely says that in there. So if the tenant is going to pay for insurance, you can put that in here, fine. But it's not like otherwise the landlord is obligated for it. The landlord's not obligated to pay for the tenant's personal property insurance.
Also nice socks too. I have.
Thank you.
Sharp favorite, they're all just socks. You can get it, won't you?
Yeah, if you guys have kids, Happy Socks, they love socks with all different things. For those of you in the other office, I have Star Wars socks on. I'll send you guys pictures. Okay. Landlord's access to the property. We were talking about this before. The landlord can access the property at any time to protect or preserve the premises. There's a fire, smoke coming out, and they can't get in the property, they can break the door down with an axe and put out the fire. They're allowed to do that. It's an emergency. Or after reasonable notice to the tenant at reasonable times for the purpose of repairing the premises. Okay? So they do not have to get the tenant's permission to repair the premises. They just have to give them reasonable notice. It does not say 24 to 48 hours. However, most people think that 24 to 48 hours is reasonable. There's no law that says that, but most people believe that. If the tenant has special circumstances though, for instance, I had a tenant one time call and ask for advice. They had a child that was disabled somehow. I forget what the disability was, but it was a big endeavor to move the child from their room to a different part of the house. They had like, you know, I don't know if they had MS or something like that, but they were pretty much bound to their room and it was a big endeavor to move them. The landlord needed to get in to do something to the property and they had to move the kid. Well, the tenant was like, they have to give me a lot more notice than just a day or a couple hours. Like I need to be prepared for this and it needs to be scheduled. So in those circumstances, 24 to 48 hours may not have been reasonable. So, you know, that's why it doesn't just say 24 to 48 hours. And there is no actual definition of what is reasonable because reasonable is different depending on who is actually occupying the property.
Now, this is really dedicated towards the tenant being able to give accessibility to the land.
Yeah, so the tenant has the right to quiet enjoyment. The tenant is living in the property, but they don't own the property. So they have rights, right? But the landlord owns the property, so they have rights too. So this section is trying to just, you know, figure out, well, who can access what when. Now, this is the money section here. The landlord has access to the premises to inspect it, to make necessary or agreed upon repairs, decorations, alterations, or improvements, supply agreed services, or exhibit the premises to prospective or actual purchasers, mortgagees, which would be the bank, tenants, bless you, workers or contractors under any of the following circumstances. With tenant's consent, okay, so they ask permission, the tenant says yes. Great. In case of emergency, or when the tenant unreasonably withholds consent. So if we are operating under this lease and the tenant says, no, you can't show the property, the tenant is defaulting on this section of the contract. And the landlord absolutely can bring prospective purchasers in so long as they give reasonable notice. And then the question is, well, what is reasonable? So that's a situation where we can get a landlord tenant attorney to jump in and write a demand letter, threaten to evict the tenant and that sort of thing for breach of the lease. right? If the tenant is being that unreasonable.
I've had
Question.
I've had tenants who've actually changed the keys. and then give it-
Yeah, tenants are not allowed to change locks
and then give it-
without permission.
And then give it set to the landlord.
Yeah, question.
I saw the definition on page 12 of that, and it says like 12-hour notice between 7 and 8.
Oh, do they have that in the statute later?
Yeah, 83.53 at page 12 of the.
Okay, we'll look at that in a second. Homeowners association approval. If such approval is not obtained prior to the commencement of the lease term, either party may terminate the lease by written notice to the other, given at any time prior to approval by the association. And if the lease is terminated, the tenant will get their deposits back. Okay, so I have some tenants that are like, I need to get out of this lease. How do I get out of it? If there's an association and they haven't been approved yet, wait until the commencement of the lease term and say that the association has not approved me. I am terminating the lease, and they are allowed to do that here. However, if they didn't use good faith and diligent effort in applying to the association, they run the risk of the landlord saying, no, you're in default of the lease because you didn't apply on time, you didn't give them the proper information or anything like that. So if you're calling me up with a tenant that's like that, I can say, yeah, this section says that, bless you. But if I don't have all the information and I don't know that there's a dispute about, oh, they didn't apply within 5 days, or they didn't give all the information to the association, we're going to look like idiots if we go to the landlord and say, hey, the tenant is canceling because they didn't get approved by the association. And then the landlord's like, well, yeah, no shit, they didn't get approved. They didn't give them this information. You know, they followed up, the association doesn't allow pets, and they didn't give them the emotional support animal documentation. You know, all of these different things. That's the tenant not using good faith and diligent effort in applying. And so this section's not going to help if they actively prevented themselves from getting approved. Okay, use of the premises is for residential purposes. They can't run a business out of the property. Okay. I'm going to jump down to the section that Kyle was talking about where we have the definition of reasonable. Oh, I'm sorry. Before I do that, early termination. I mentioned this earlier. If this section is filled out, the tenant can terminate the lease early and they can pay a dollar amount here as liquidated damages. It cannot exceed 2 months' rent. So in this market in particular, there are many tenants who are leasing only because they haven't found something to purchase. And their strategy is to enter into a yearly lease and then terminate the lease early by paying 2 months rent, and because they found a house to buy. Okay, great. But if they check off the second box, then they can't do that. As soon as the lease is signed, the tenant is obligated to pay for the entire term of the lease. And if they do not, this section will control. So if they have 2 months written in here or a certain dollar amount for liquidated damages, then that is what they are obligated to pay to terminate the lease early. Okay.
You're responsible for the remaining part.
Right. Otherwise, they're on the hook for the whole thing. All right, Kyle, you said page 12.
Yes.
Let's look at that.
Page 3.53.
Okay, landlord's access to the dwelling unit. Here we go. Reasonable notice. See, we're learning something new here. Reasonable notice for the purpose of repair is notice given at least 12 hours prior to entry, and reasonable time for purpose of repair shall be between 7:30 a.m. and 8 p.m. Okay, so they're defining reasonable notice for the purposes of repair, but not for anything else.
12 hours is not a long time.
No, but it is for repair, so it could be to prevent an emergency from happening later.
Like a water heater is leaking or something.
Yeah.
Chances
Okay.
are, if you call your landlord, they're not coming within 12 hours. That's the experience I've had.
Yeah, exactly.
Is the landlord
Question.
obligated by a lease agreement to do a repair in a certain amount of time, like if an AC is busted or something?
Okay, so the question is the landlord obligated to repair something within a certain amount of time? I don't believe so. However, there is what's called the implied warranty of habitability. If there is something preventing the property from being habitable, and in Florida, air conditioning might be such a thing, then the tenant has the ability to abate their rent, meaning they can either reduce the dollar amount of the rent by whatever it costs to repair, and they should be talking to a landlord tenant attorney before they do something like that. Okay. Or they can put the amount of money in rent that they're supposed to rent in escrow, so that they show in good faith that they had the amount of money in escrow. And then if the landlord tries to evict them for not paying rent, then they can present that to the judge and they can say, well, listen, the landlord didn't do this and I made requests, so I was unable to use the property, so I shouldn't have to pay rent. And in good faith, I put the money in escrow in case I was wrong. They need to talk to an attorney about doing any of that stuff. And I'm not the attorney to talk to about it. You can ask me, but I'm going to refer you to one of the landlord tenant attorneys that we work with, because that's not what I do on a day-to-day basis. And I'm not up to speed on all the different changes that are happening with leases. Also, speaking of changes, in Miami, they passed a code ordinance that says that a landlord cannot raise rent more than 5% without giving 60 days notice. So everybody knows that, but that's only Miami.
What some landlords are doing, if they don't do that, we're just choosing not to renew your lease.
Yeah, and then so Kyle just commented, yeah, and then if the landlord is just not going to renew their lease if the tenant doesn't agree anyway, which they have the right to do that anyway. So it's a tough market for tenants and buyers anyway right now. So, but don't forget, we just went through COVID and a bunch of people didn't have to pay for their rent. And it just there was a moratorium, and then a bunch of landlords got screwed. So why are landlords only accepting people that are paying in cash for a year up front? Because we just went through a year where they didn't get paid. So, it goes both ways, unfortunately. Okay, all of this stuff that I'm scrolling through right now, these are the statutes. So the entire rental statute is in this contract. So if you do control find and you're looking for something, you might be able to find it in the lease. Okay, I'm going to briefly talk about the multi-unit one now too, because it's very similar, but there are some differences. The residential lease for apartment or unit in multifamily rental housing other than a duplex, including a mobile home, condominium, or cooperative. So if you have a duplex, you're using the other lease for single family. Okay.
A villa would be this one?
A villa, what you mean, like in an association
Yeah,
and
in
it's a
an
house?
association.
That would be the single family,
Yeah, it's a home.
because it's a homeowners association.
All
This would be for a
HOAs.
condo association. Yeah.
Oh, okay.
Yeah. So HOA related ones, you're going to do single family, unless there's like a triplex in an HOA. There are some condos that are also within an HOA, so there's multiple associations.
Yeah, I was gonna say, because sometimes it says, it looks like a townhouse, but it's
Right.
legally says it's a condo.
Yeah, townhouses are generally single family, but some townhouses are actually condos. You need to find out. Yeah. There are common areas. That's one of the key differences, right? There's no common areas necessarily in the HOA. There might be, but this lease addresses that. Okay. Lease payments must be paid in advance, beginning on whatever date. This section is a little bit different. It says the security deposit to be paid upon signing the lease. So you can't put in here when it's due. So if you're using this lease, this is a very big difference from the single family one. If it's not going to be paid upon signing, then you need to cross this off and you need to put paid upon you know, commencement date or occupancy or something like that. So it's very important to understand what the tenant is signing here, because all of this stuff is saying that it's due upon signing. Notices. It says here, landlord's agent for the purposes of notices. If you are not the management company or managing the property after the lease for the landlord, don't put your name here. Because then otherwise you're going to be receiving all the notices or formal notices on behalf of the landlord. You're signing yourself up to do that. But if you're not managing the property, why are you doing that? Your only obligation is to list the property and get it under contract. Okay, let's see. Maintenance section is a little bit different. They have the check boxes. But then, like I said before, there's a dollar amount here. Okay. Tenant's responsibility, if any indicated above, shall include major maintenance or major replacement of equipment. So if you check tenant here for the air conditioning, then the tenant is responsible for major maintenance or major replacement of the air conditioning unit. Right? Okay, and then so it says landlord shall be responsible for major maintenance or major replacement of equipment, except for equipment for which tenant has accepted responsibility for major maintenance or major replacement in the previous paragraph. Major maintenance or major replacement means a repair or replacement that costs more than blank, right? So anyway, you need to figure out what the tenant is supposed to be responsible for. And if you check off tenant here, it is for major maintenance. So for the most part, landlord is responsible for almost all of these things in normal multi-unit places. Let's see. There's not a ton else that's super different on this one, but those are the major ones.
So just to confirm, if I am putting a lease together for a condo, this is what I have to put.
Yes, you're going to use this for a condo. Yeah.
If let's just say the tenant or the landlord's agent sends me the other one, but it's a condo, would I then just tell them to do it? Is it interchangeable?
It depends. You could use the single family one on a condo. If the landlord's presenting you with that, okay, fine. It's not that big of a deal. But yeah. But the thing is, this one is for a condo. Now, there could be a condo that is not a multi-family condo, you know? So it's almost treated a little bit more like a single family residence. Yeah. So like for a townhouse, for instance, like you said, that's actually a condo, you might be able to get away with using the single family one and it's like exactly the same. So I have seen leases that apply to both. A lot of people use the single family one just by accident without even knowing. It doesn't mean that the lease won't be enforceable. There's no way that a judge is going to say, oh yeah, the whole thing's unenforceable because you used the wrong form, you know? So if that's what they send it over to you in, that's okay. You know, it's not that big of a deal.
Now, if it's like an efficiency or something like that, I would still have to use
the single family. Yeah, for an efficiency, use it as single family. Yeah. Okay, and the thing is, they're not that different. Okay, I'm just trying to see if I had other stuff after this before I go to the post occupancy. Okay, side note, initials. The initials are on all the pages, including all the statutes, right? Because they want to confirm that you presented the statutes to the tenants. for their protection. So the leases are long.
It's like fancy paper.
Yeah. Okay, I'm going to show you guys the post occupancy addendum too. Let me pull that up. Oh, I think I have that open already, actually.
I have learned so much today. Thank you so much.
You're welcome. I'm glad that you guys are enjoying.
I know, every time.
Actually, I keep her back on you, so.
Two different things. Is the way
Contract
rent
lease.
run now, then.
I mean, I lived on that
To
for
get the
like
money back.
ever.
Right.
Like at least like 2 years.
My
Your
God,
reputation,
I lived
you
on that.
buy it, it's just, it's a big
Okay.
headache.
I lived on that.
Nope, that's not it. Where is it?
You lived on what?
Contract lease.
Yeah,
Oh,
I
yeah.
lived on a contract
Thing you
lease.
need to do.
Seriously, I used to submit like 4 or 5 a day.
Right, and you were writing them wrong.
Crazy.
My God. You writing the dollar amount?
Yeah, I was writing a
Yeah.
dollar amount because sometimes the contract doesn't go through and I'd already have the money in escrow. So I just write another
Okay.
one with the same escrow.
Um,
No release, no nothing.
So because I have this in this training that for addendums too, I'm just gonna briefly cover it too. Appraisal contingency, you guys are seeing this a lot. I don't like using this form for various reasons. A lot of you have reached out to me for appraisal language. Thank you for asking. The number one language that we see that gets everybody into disputes says buyer is willing to pay $10,000 above appraised value. End. Nothing else. That language has led to more disputes in the last, I don't know, year than anything else that's in the contract. Okay, so this is the language that I like. Okay, there's 3 different parts to it, and you can mix and match with it. So buyer and seller agree that should the property appraise for less than the purchase price and greater than blank, the purchase price shall not change. Okay, so if the buyer's paying $10,000 above appraised value, you're writing whatever is $10,000 less than the purchase price here. And it's saying, okay, the purchase price not going to change. That locks in the seller's $10,000 extra, right? This paragraph talks about if the seller is going to reduce the purchase price. Why would the seller ever reduce the purchase price? Let's say the property is listed for $500,000 and the buyer comes in with an offer at $550,000. But we all know it's not going to appraise for $550,000. The seller's just willing to take a chance that it's going to appraise higher than $500,000 because we think that the appraiser is going to be influenced by the purchase price or whatever. If the buyer is willing to pay $10,000 above the appraised value, right? But we think it's going to appraise for $5 or $510,000, and the purchase price is $550,000, the buyer needs to be protected there. And the seller might be on board to say, well, yeah, I'll lower the price to $540,000 if it appraises at $530,000. Okay, so that's what this language is here for. I don't expect you guys to just plug in everything there. You want to take the language, you want to, maybe you can plug stuff in and then have me review it and explain to me what's going on. Okay, so I'm not just giving this to you so that you're on your own doing it, contact me. And then the last paragraph is an actual appraisal contingency. If the property appraises for less than blank, then the parties shall renegotiate. If they don't come to an agreement within 3 days of receiving the appraisal, either party may terminate the contract. I have been more successful with this language than the appraisal contingency. And I believe the reason why is psychological, because this appraisal contingency says the buyer can terminate the contract if it appraises below a certain dollar amount. My language is saying, well, the seller can terminate it too. Who cares? The buyer doesn't care because they're not going to pay above that dollar amount anyway, right? So the seller wants to protect themselves and not sell the property for too low. And so they feel like this is giving them more options. So it's not really that big of a deal, but psychologically, I've found that it helps. Okay.
And you're emailing that to me?
Yeah, you have this one.
I have bits of
I
that.
just, yeah, I sent you, no, but I sent you this document.
I've used like 3 different, I think I've used all 3 parts of that.
Yeah, and I have other language too. I'll show you in a second because it's not on here. If you have the listing and the buyer is waiving the appraisal, I have specific language for that too.
Cause I was gonna ask, because even if they waive the appraisal, they still have to get approved by the.
Yeah,
You still have to get it anchored.
yeah. We're gonna do,
They're just saying that they'll
Yeah.
pay.
so I was gonna say, Courtney, side note, let's talk with Mike about maybe doing a joint thing about lending, and then also I could talk about the financing contingency. Because there's so much to talk about with financing contingency, but it's good to be on the same page with lenders, so.
Because I was just asking, because in regards to this, I do see a lot of people.
No more Mike, or whoever we're with now.
Yeah, just in regards to that, because I've had a lot of agents who are like, all right, they can waive the appraisal, but if the lender still is not going to not approving them because they don't have enough.
Yeah, so I'll go into this a little bit in a second. Let me do the post occupancy, because we were talking about leases and post occupancy. But then we'll talk a little bit about waiving appraisal too. Okay. Okay, I don't like this addendum either. And for a couple reasons. It says this contract is contingent upon buyer and seller within blank days delivering to each other a mutually acceptable written lease. What if they don't come to an agreement? If the contract is contingent upon this, then that means the whole contract can be terminated because they didn't agree. So I don't want to give the buyer or the seller an extra out to this contract, right? So I don't want to use this addendum. Also, there's no escrow dollar amount here. How much is the seller supposed to keep in escrow at closing? If you have this addendum filled out and then you ask me to draft a post occupancy agreement and I say, well, how much in escrow? And we're looking at this, there was no agreement for that. So, a seller may say, well, I didn't agree to put an escrow in, I'm not doing it. And if you have the buyer, now your buyer's screwed, there's no escrow. And if the seller destroys the property, there's no escrow for them to go after, right? Yeah, if you have the seller, then fine, they don't have to put any money in an escrow, right? So I don't like using this addendum. I just have specific language to put in the additional terms. All of these things are going to go into the post occupancy agreement, or let's say there's not a penalty. Let's say you have the seller. You don't want to penalize the seller for staying past, you're just not going to put that in there. So you're going to delete it. But if you have the buyer, you don't want the seller staying past 30 days. So you want to put a penalty in there for them, right? So this is just generic language that you can just fill in the blanks on, and you can delete whatever you're not agreeing on to. Rent, if it's $0, don't delete rent, put $0. Okay. And then all other terms of the post occupancy agreement to be agreed upon prior to closing. But it does not state the whole contract is contingent upon agreeing to them, right? That's a major difference between this and the post occupancy addendum. Okay. Any questions about post occupancies?
So structurally, you need to have a lease put together.
Yes. So you're going to have this addendum, and then my office, if I'm doing the closing or I'm representing the buyer or the seller, whatever it is, we will have the contract and we can quickly put together a post occupancy agreement, and I can use this to fill in the blanks. So I can draft a post occupancy agreement incredibly fast as long as we have the file and the contract, because I could just click a few buttons. But if we don't have an addendum that's guiding us as to what's supposed to be in there, then I'm going to have to ask you for all of these things, right? So at the outset, when you have the listing of the contract, you need to have an addendum for the post occupancy. You can't just rely later that the buyer is going to give you a post occupancy. You have to have that upon execution of the contract. And then you don't want to have to wait for me to put together a post occupancy agreement. And I'm going to say, well, I don't even have this file yet. It's not executed. Why, I could give you a draft of one, but that's an addendum to the contract. Why don't you just put this together? So the steps are put this together, send it to us, and then we could draft the post occupancy agreement whenever the heck we want prior to closing,
So ideally, because the way I'm seeing things going right now is a lot of sellers are looking for that post occupancy.
Yes. If you're on the buyer side and you're not submitting an offer with a post occupancy agreement, you're putting your buyer at a disadvantage compared to other buyers. Sellers don't even know that they want a post occupancy agreement if their listing agent isn't talking to them about that, right? But if you come at them with an offer that has a post occupancy agreement in there, now all of a sudden, oh my God, this is a whole new avenue, so there's a lot of listing agents that aren't thinking about that. If you, from the buyer side, are trying to figure out ways to get your offer in, offering a post occupancy agreement is a great way to do that. And you can talk to the lender, but up to 60 days is the maximum for most loans.
Who figures out the dollar
You
amount?
do, but you use, like, go look at comps, like rental.
Okay.
Yeah.
comps in the
Oh,
area.
rental comp.
So you have to talk to your tenant. I mean, not your tenant. You have to talk to your buyer, okay? There are a lot of buyers that are making an attractive offer to the seller by not charging them rent. But that means that they're gonna close and they're gonna have a mortgage payment potentially with someone else living in the property. So can they swing having a mortgage payment and, staying wherever the heck they are right now? So they may need the seller to pay them rent at closing for that dollar amount. But it's a seller's market. The seller may have some other offer that has no rent. But I would not ever recommend doing a post occupancy agreement without having an escrow holdback. You need to have an escrow holdback because you've got to have something hanging over the seller's head so that they get out on time and that they don't damage the property.
So are post
Question.
occupancies never supposed to be more than 60 days?
Post occupancies are almost never supposed to be more than 60 days for a financing deal.
Right.
The lender, if they see a post occupancy agreement that has more than 60 days, they are going to say this is invalid. So if you have a contract that says up to 70 days or 90 days after closing, and the lender has that, they're going to say you need to amend this contract, and the post occupancy has to be shown to us with having no more than 60 days.
Because then they look at it as investment property, right?
Because they look at it as an investment property. You can write the post occupancy agreement to say 60 days. And then if they stay past the 60 days, there's a penalty of X amount of dollars a day. But the termination date on the post occupancy agreement is still 60 days.
So we'll cut down a couple other questions. If you go past the 60 days, is there something we're supposed to be doing there as far as the Florida, 13% tax? Is that something we're supposed to be looking at?
So the question is about taxes with post occupancy agreements. I have had one other realtor ask me about this ever. Okay, so good question. In the post occupancy agreement, it states that the taxes are not included in there. It is up to the buyer to pay taxes, right? Just like it's up to everybody who's supposed to pay taxes, it's up to them. Technically, I believe there is supposed to be tax paid as a short-term rental. However, almost no buyer ever pays it. So me as an attorney and you as a realtor you shouldn't be advising them one way or another. You should say, you need to talk to an accountant about that. Okay. And me as an attorney, I'm going to tell them, yeah, you need to talk to an accountant about that. Right? Technically, they are supposed to be paying the transient tax on it. Nobody does it though, but they are supposed to.
And that 60 day applies to financing on a primary residence, not a secondary property.
Yeah.
And what about like the damage thing? Like, how do you know?
You're going to do so with a post occupancy, you're going to do a walkthrough prior to closing, maybe. Okay. But in the post occupancy agreement, it states that the seller has to keep the property they have to maintain the as is maintenance requirement that's in the contract. So you did an inspection. Okay. The inspection period was 7, 10, 15 days, whatever it was. From that point forward, you probably have either a credit addendum or there's supposed to be some repairs or something, or maybe there's nothing. From the end of the inspection period forward, the seller is supposed to maintain the property in its condition, in its as is condition, right? But if you're closing and then they are remaining there, how do you know that the property is in that condition? You could do a walkthrough prior to closing, okay? And then you could figure that out and say, hey, this stuff needs to be fixed either before we close or before the end of your post occupancy, right? But you're going to do another walkthrough, just like you would do with a tenant at the end of the post occupancy. And then you should have a security deposit that you could say, well, this stuff needs to be fixed, all of these things need to be fixed. But if it was the same condition as it was at the end of the inspection period, the seller has an argument to say, well, no, it was like that at the end of the inspection period. I'm not fixing anything. Give me my deposit back, right?
So it has to be, so your request have to be done during the inspection period, but it can prolong itself to the end of their, post occupancy.
Yeah, my post occupancy agreement states that the as-is maintenance requirement shall be maintained during the entirety of the post occupancy. Right? And then I always recommend having an escrow from the buyer side. So you have to be careful with that stuff. Okay.
What about HOAs on some of this stuff? Have you seen any pushback at all from the HOAs? Because a lot of times when you buy a house,
Mm-mm.
technically you're not allowed to rent it out for a year. Well, how does
Yeah.
it work with,
I've had condos with post occupancies cause a problem.
Okay.
But very few and far in between, because they're like, hey, why is this person still here? It was sold. But most associations, they've already approved the owner that's there, and they don't really care. But that being said, there's a very real possibility that an association can find somebody for doing something like that.
So say we get into an instance, we sell a house, have a post occupancy, everything's worked out, and then the HOA says, sorry, you guys can't stay there. What happens?
Well, there's going to be a dispute, obviously. The question is whether or not the dispute is going to be resolved before the seller has to move out. So, if it's a gated community where the seller has access to the property, right? The association could turn off their swipe pass and not let them into the property. So you got to be careful of that. Like with quitclaim deeds, I always advise clients who are doing a quitclaim deed, hey, you have an association, you should get this approved because you're transferring your property, right? You guys as agents, if you are going to do a post occupancy agreement, you should find out from the property manager whether that's allowed first. You absolutely should be doing that. Why? Because people talk in communities, right? You don't want to run the risk that seller is telling somebody that they know in the community what they're going to be doing, and then that person goes and tattles on them to the association. And then in the middle of the contract or the end of the contract, the association says, you guys can't stay here afterwards. That's going to blow up your transaction, and it's going to hurt your commission because you either won't close or there's going to have to be some sort of credit negotiated. So I always want to have in writing approval from the association, because that is going to protect you. That does not happen all the time. It just doesn't. So people take that risk. The listing, yeah, well, if you're from the buyer side, so here's the thing, from the buyer side, the tenant could be fined or something like that for renting it, right? Or the association could force the tenant to evict the seller. From the listing side, the listing agent really needs to know whether or not they have permission to do that.
But to protect our
Because then, so from the buyer side, you could go back to the seller and you could say, listen, the association doesn't allow this. We have to change the contract. Then you're kind of protected there.
Maybe you just move back to, I would say move back to closing, but
we have.
Yeah, usually we move closing dates to accommodate stuff like that.
We had one that moved back by 5 days because, like Steve's been saying, that the financing term is 60 days. This person needed 65 days, so they're asking us, well, what if it's 65? Listen, financing states 60 days. And that's
Yeah, you can't, exactly. So Andre is talking about, we need 65 days. And the lender said, well, it has to be 60 days. And everyone's like, well, what do we do? Well, you guys as Florida licensed realtors cannot say, oh yeah, it's okay, just do 65 days. And me as an attorney cannot just say, oh yeah, just do 65 days. right? And the lender cannot accept a document that says 65 days on it, right? So either we move the closing date, to a date that will accommodate the seller, right? Or we have a post-occupancy agreement that says 60 days. Now, there are also penalties for the seller if they don't move out on time. Lenders will accept that document. And all of us are saying your termination date is 60 days. And seller, if you don't move out, you're going to be penalized. How does the buyer collect that money from the seller if they, don't move out on time? Can the seller be evicted? Can the buyer claim extra money? Absolutely. But you guys as agents can't advise people to do things that would be mortgage fraud. Okay.
Can I act like a realtor right now? What about insurance? If I'm on the buyer side and we have a post occupancy.
Insurance for the buyer side for post occupancy. Great question, Andre. My post occupancy agreement says that the seller has to maintain insurance for renter's insurance if they want to protect their personal belongings, and that the buyer is not responsible for their personal belongings, just like a lease. Then it also says that the buyer is responsible for risk of loss and must maintain casualty insurance on the property, right? Because the buyer is going to have to get insurance anyway.
Yeah.
And I spoke to an insurance agent. This is if it's a financing deal. If a buyer is a cash buyer, they don't have to get insurance for their property, but absolutely. So the other thing is the insurance person that I talked to about this, they said that most insurance companies are not looking at a post-occupancy agreement and don't really care about that. But if it's a long-term lease, they obviously care about that because the insurance coverage for the people that are going to be in the property is different if you have long-term renters there, right? So that's on the buyer to check with their insurance company to make sure that they are properly insured, okay? And then I'm just going to share the appraisal waiver language too, so you guys see this. Okay, just quickly jumping back over to the appraisal language and the new contract. Under the new contract loan approval period, it says that the appraisal has to get done during the loan approval period, right? We have buyers submitting contracts that say buyer shall waive appraisal contingency. That means nothing because there is no appraisal contingency in the contract. Okay, so how do we get the buyer to waive the appraisal? This is the language that we've come up with. Buyer agrees to waive any appraisal conditions of the loan approval. Notwithstanding any other section of this contract, buyer shall not apply for a loan conditioned upon appraisal or alternative valuation and may not terminate the contract due to the property not appraising for the purchase price, regardless of whether or not the appraisal is received during the loan approval period. Should buyer attempt to terminate the contract due to failure to obtain loan during the loan approval period, buyer, this should say loan approval. Buyer and lender shall provide all conditions needed to obtain loan approval to seller prior to termination. And the reason we say that at the end there is because the buyer doesn't have to give anything to the seller if they are terminating because they don't have the loan approval. And we need to put something in there to protect the seller to figure out whether or not the buyer canceled because the appraisal came in low. So if they truly are waiving the appraisal, there's no protection for the seller unless you have something like this stating that they're not even applying for a loan that has a condition of appraisal. That's a can of worms for a buyer too, because if their property appraises $100,000 less, there's very few circumstances where there's going to be enough collateral to give them the loan that they applied for. So I don't recommend waiving appraisal from either side, to be honest, because I want the deal to close. I would much rather have our other language that says the terms of, if the appraisal comes in for this, this is what we're going to do. If the appraisal comes in lower than this, then we're going to renegotiate. This language for waiving the appraisal It's very, very difficult because there is no appraisal contingency in the contract. There is only loan approval. And if the property appraises low and the buyer doesn't get loan approval, then the buyer doesn't have loan approval. So it's a very big gray area in this new contract. And I don't like how the new contract is written with this, but if we're going to try to do it, this is the language that we're trying with. Okay. Yes.
Yeah, because I was getting some pushback in regards to waiving the appraisal. It's like, okay, you still have to get a loan approval. Doesn't make sense.
So Roni's talking about he got pushback and, someone wanted your client to waive loan approval. Yeah. And so his response is, well, we have a loan approval period. If you're okay giving us a loan approval period, why would we waive appraisal? So you're telling me that I have all these other conditions of loan approval and then the appraisal comes in low, but I can't cancel, but I have all these other conditions. So what do you really care? So in that circumstance, this is where you got to be on the same page as your lender. When is the appraisal supposed to be done? Can we get this appraisal rushed and can we get this done quickly? And then maybe you can negotiate with the seller and say, well, listen, why don't we say if the appraisal is not done in 14 days, then you can cancel the contract because it's taking too long. Or why don't we put our appraisal contingency in here? We'll pay more above whatever market value is, and we'll pay above whatever the appraisal value is. But if it comes in too low, then we either got to reduce the price or we got to cancel the contract. You, as an agent, need to be able to negotiate that. If someone's coming at you from the buyer side saying waive appraisal, you've got to be able to say, well, listen, there's no appraisal contingency in here. There is only loan approval. We're either getting the loan approval or not. So if you're okay with the loan approval contingency of 21 or 25 days or whatever, you shouldn't care about whether or not we're waiving the appraisal because we're either going to get loan approval or not. And if you're that concerned about the appraisal, then it means you think you listed it too high. But guess what? My buyer can pay X amount of dollars above appraised value, right? Also, FHA and VA loans, you cannot waive the appraisal contingency for those. That would violate federal law. Okay, so a listing agent that wants you to do that on a VA or FHA loan doesn't know what they're talking about. But especially with VA loans are great. You've got to be able to convince the seller and the listing agent that a VA loan is even better than a conventional loan in terms of how you can get approved for it. But also the buyer in that circumstance may have extra cash to pay because they don't have to put any money down. Right? So that situation, you might be able to say, yeah, if the appraisal comes in low, the buyer can pay X amount of dollars above the appraised value. You can't contract around their ability to cancel the contract if it appraises low, but they want to buy the house. And if they're comfortable paying $10,000 above, well, they're comfortable paying $10,000 above. Why are they going to back out in the future over that? So that's something that you need to be aware of. Yeah. Courtney, I'm going to send you everything that I haven't sent you yet, and then you guys can post it in the Slack and do all that stuff. If you have any questions, reach out to me like always. The Slack, sometimes I don't get notified for whatever reason. It doesn't, I know you guys go through it too, but shoot me a text if you don't get a response from me on Slack. And then of course, if I'm doing a training like this or something, I might not be available for a couple hours, contact Andre, contact Tati, whoever you're in touch with at our office to get an answer, or at least tell me, hey, get on the phone with this person right after you're done, So, yeah, that's pretty much it.
So are you seeing like every contract coming in with the post occupancy?
We have a lot of post occupancy, a lot.
It's funny, 'cause like 2 years ago, you're
Yeah.
like, I advise you not to.
Well, no. I would not want to have a post occupancy agreement. So Ronnie said, in previous trainings, I've said, don't do a post occupancy or a pre occupancy. I don't like them. And I agree. I still don't like them. But the way the market is right now, there are tons of post occupancies because there's no inventory. So it's not that we can't do them. Yeah, we don't want to do that. We don't want a seller staying in a buyer's house after the buyer bought it. We don't want that. But that's the way the market is right now, So it's not that we're not able to do certain things, it's that we don't want to, but
To complicate the deal. But
Yeah.
Right now, a lot of people just want that cash in their hands.
yeah.
They're
And then
strong.
go
with
buy
the other-
something else.
Also, okay, I never advise clients to pay for title insurance, even though I get paid for it. But in Palm Beach County, buyers, you can only offer the purchase price so high. You know, like if it's not gonna appraise, how does that help the seller out? So what are other ways to distinguish your offer? Have the buyer pay for title insurance. It's a couple $1,000s, you know, compared to the cost of whatever they're paying above appraised value, and, you know, whatever they're paying above list price, it's pretty inexpensive, you know? So I've had buyers agents get under contract because they were able to distinguish their offer. The seller's gonna net more money if they're not paying for title. So whatever the seller is normally paying for, if the buyer is able to actually pay for that as a closing cost, maybe they can wrap that into their loan. You know, so title insurance is one of those things where it's a closing cost that can be amortized over the term of a loan. You know, they may not have to come in with extra money at closing, but it nets the seller more. That's one of those things that you can offer to try to get under contract.
Now, just to clarify, you're talking about the title insurance, not the owner's policy.
Yeah, no, the title insurance premium.
Okay.
Yeah.
Because we were having a conversation. with
What's that?
Is that, sorry.
No, I was having a conversation with somebody who was talking about okay, you're gonna pay our title, or you're gonna pay, like.
The owner's policy versus.
Well, not an owner's policy,
Lender's
but
policy.
no, they were saying like, okay, you're paying for title. And it's like, okay, I can only pay for the owner's policy. I can't pay for your taxes. Is that right?
Okay, so in section 9 of the contract, there's all different closing costs and fees that the seller or the buyer are responsible for. One of the things you can shift is title insurance and the municipal lien search and the title search just by checking different boxes, right? So if box 9C1 is checked, that's typical for Palm Beach County. Seller chooses title, pays for the owner's policy, and chooses the closing agent, right? If you check box 2 or 3, then the buyer is paying for the title insurance. All of the other fees that are in there, like doc stamps on the deed, you could cross that off and make that a buyer responsibility to pay, you know, but then the buyer just has to come in with more money at closing. You know?
Because I thought there were certain things, I know the taxes, like the seller has.
The tax prorations, so I mean, even tax prorations. So the way tax prorations work is, let's say we close June 1st, okay? The seller is supposed to be prorating the amount of taxes it would normally be for half the year, okay? So if they're paying $5,000 in taxes at closing from the seller's proceeds, $2,500 will be transferred to the buyer, because in November, the buyer's gonna have to pay $5,000 for the whole year of taxes. So normally what happens is the seller has to prorate. You could negotiate with the seller to where there's no tax proration. That's just more money that the seller nets. And then the buyer has to pay for the full taxes in November. Anyway, you could negotiate that. Absolutely.
And is that also Broward?
So Broward and Miami, the buyer is paying for title anyway. So it doesn't, yeah, that's standard. So the buyer's not offering anything different than anybody else would be offering. But in Palm Beach County, normally the seller's paying. So you're saving the seller a couple extra $1,000 if the buyer's paying for it, you know?
CJ, can you explain the seller reps?
Yeah,
Miami Dade,
so-
what it is?
Okay. We've got a couple people in here still from the other office too. You guys are based in Palm Beach. You have an office in Broward now, okay? You guys have done deals in Broward. You guys from down south have done deals in Palm Beach, okay? Our office is a law firm. We're not a title company, which means we can represent both buyers and sellers, which means in Palm Beach County, we can represent a buyer, okay? And we don't do the closing because the seller chose the title company to close. But we can represent the buyer, and they pay us for that, and then we review everything that the title company does. In Broward and Miami, when you have a listing, we can represent the sellers, okay? If you haven't dealt with that before, it's a no-brainer. The seller is going to be charged a settlement fee and a doc prep fee or whatever a title company is going to charge them. If we are representing the seller, we provide them legal representation, we create their documents, we sign them ahead of time, we pre-sign them, just like we do for sellers in Palm Beach County, okay? And then we charge them $5.95 for it, plus a $75 courier fee, because we got to bring the documents to the title company. Those fees replace whatever the title company would have been charging them. So not only do they get legal representation, in some cases, they might actually be paying less than what they would have been charged originally. Because there are some title companies that are charging $700-800 for settlement fees for sellers. And we've dealt with them. Some of them are over $1,000. We're not charging that. Plus, they get legal representation. We act as a mini transaction coordinator for you guys in terms of talking to the title company. Any addendums that need to be created, we draft for you guys too. You know, or give you advice as to what should be in them. And if shit hits the fan with the buyer and they can't close, we're there to represent the seller. We can negotiate an addendum where the credit is transferred to the seller, right? But if we're not on the file, then we don't know anything about it. Post occupancy agreements, all of that stuff, So a lot of, because you guys are in Palm Beach County, you don't necessarily know a lot about seller reps. We do that. That's very common. It's a very big part of what we do, and we're based out of Broward and Miami. And even though we have offices everywhere, a lot of our deals are in Broward and Miami. Port St. Lucie, Martin County. Yeah, Brevard. We can close anywhere. Those counties, we have reduced settlement fees because the standard up in those areas is a lot lower than Palm Beach, Broward, and Miami. So we're charging $3.95 for settlement fee. Most of the agents that we work with in those areas, they are having their clients pay for title no matter what, whether they're the seller or the buyer. Why? Because they want to control the transaction. And they're telling their clients, hey, you don't have to do this, but it is better if you are controlling the transaction. Think about it from the seller side in Palm Beach County when the seller chooses the closing agent. Now the closing agent that the seller chose is in direct communication with the lender. If we're in Broward or Miami and we're representing the seller, we don't know what the heck the lender is doing on a day-to-day basis. We can't just call them up and expect to get whatever we want from them. But if we're the closing agent, they have to keep us informed because we've got to figure out when we're closing. So, having the ability to control the transaction is important to some people. And because the purchase prices are lower up in Port St. Lucie and Martin County, usually they're below $400,000. It's like $1,000 extra to pay for title. It's not really that much more, So again, this is not me saying, do this because I will get more money and it's better for me. It's because it might help facilitate the transaction better. In Palm Beach, from the buyer side, you might get your offer accepted if you offer that, and it's very competitive, So these are different things that you can use to negotiate.
So my condo that I'm selling in Broward, I put that you guys are doing the closing.
Yeah. So.
And then my purchase in Palm Beach, I
Yeah.
said that you guys are doing the closing.
Yeah, you're a special situation because I'm not gonna.
You're special.
You're a special situation. So, but your client though, they would pay for the title insurance and it wouldn't be that much extra, compared to everything else they're offering to try to get under contract. That's a minimal expense they actually get some benefit for it, which is the person that they chose is controlling the transaction, So, listing agents, you're looking at 50 offers. You cannot force the buyer to choose your lender. You cannot force the buyer to choose us. However, you could say to them, what would make your offer stand out above the other 50 offers that I have? Use the people that I trust. Now, if you have a $600,000 cash offer and it's using some other guy for title, and every other offer that's using us is $500,000, I would never tell you not to take the $600,000 offer. But if you have 5 offers and they're all $500,000, and the only difference on the contract is one person is using us and the other 4 people are using somebody else, your seller is gonna say, why is this one better than the other ones? Well, we know the closing agent on this one. So if there's any issues, we might have a better chance, right? So if you have buyers that are submitting these offers, especially the lender's the most important person in the transaction. The lender that you're working with, if you trust them to qualify a buyer, you know that that buyer is more likely to close. We have so many transactions right now where we're representing the seller, and then the lender completely drops the ball, and we don't know who the lender is. We can't just call them up and have a heart-to-heart with them and figure out whether or not this buyer can close. There's like a veil between us, the title company, and the lender. But if the lender is somebody that we all know and trust, first of all, they're probably not qualifying somebody who's not qualified,
Right.
right? So, you know, that's how, when from the listing side, you could distinguish your offers from the buyer. Now, from the buyer side, when a listing agent is saying, well, use my people, you got to use my people, you have to be able to explain to them, no, this is why my lender is good. Get them on the phone with your lender, right? This is why my buyer is qualified. This is why my lender is great. I use them all the time. They know what they're doing, right? You need to be able to explain that and sell that to the listing agent. This is why my team is the best buyer for your property.
Are they allowed to put that in the listing?
They can put recommended. They can put recommended lender is
Sometimes they
so-and-so, recommended. You cannot force the buyer to use a closing agent or a lender. You can't make the deal contingent on that. So if a listing says you must use this person, that's a RESPA violation.
Oh, I see.
Yeah,
Violate.
that's a RESPA violation.
Report them. Violate them.
Yeah.
Report them.
Well, you could submit an offer though, and you could, you know, I mean, you could, for the lender, you don't put on the contract who the lender is going to be, you know? So you could just submit an offer and say, yeah, we'll use your lender, and say, no, the buyers decided they want to switch, you know?
Yeah.
You know, you don't put the closing agent on the transaction either. You only put the escrow agent on. And then once you're under contract, you say, no, actually, my broker told me that that's a RESPA violation or something like that, you know? You treat, well, before you invoke Giordano, you got to talk to her about it. You can't just say, oh, my broker said this, but it is a RESPA violation, you know? So that's pretty standard. All right, any other questions, anybody? Got any questions on the chat here? No. All right, reach out to me if you have any questions about anything, and I will talk to you guys later.
Thank you. Thank you.
Thank you.